Limited against Moorgarth Group Limited.
Yes, Mr.
May it please my lords, in this matter I appear on behalf of the appellant and my learned friends Mr McGee and Mr Fowler for the respondent. My lords, I was hoping to make my submissions in the following order, if I may, dealing first with the Aveling-Barford case, but in particular the three cases before it, namely Ridge Securities in 1963, Holt Garage 1978 and Rolled Steel in 1984, and then the two cases subsequent to it, Macpherson in 2000 and Bairstow in 2001. And subject to your lordships, those were the only authorities I was going to go to, as it were, directly on the point of ultra vires distributions. I would then propose to deal with certain analogous situations as a matter of company law, and one point that I think will be made by my learned friend, and I will hand up one further authority to your lordships, and that, we say, will demonstrate that an objective assessment and analysis is de rigueur in all aspects of company law, as it is almost certainly in all aspects of civil law. I'll then deal with any points that your lordships may have in relation to the pleadings, which I noticed that your lordships asked for, and then lastly turn to the judgment at first instance and the documents, although we have very few of them in the appendix, and the Court of Appeal. Now, my learned friend and I have spoken, and again, subject to your lordships, we would hope not to take up more than the day of your lordship's time, notwithstanding the two-day the two-day notice. So, my lords, if that's convenient, without further ado, could I go to Ridge, which is in volume 2 of the authorities, at tab 22. Now, Ridge, as it were, is nothing new, because the prohibition on return of capital is right at the very outset of company law in the 19th century with the old Trevor and Whitworth case. Of course, at that stage, one really talked about the return of capital, because when companies started as really joint stock companies, they really were properly capitalised companies. The shareholders introduced a large amount of money for the purchase of a ship or a railway or something of this sort, and returning that capital to shareholders was unlawful unless in certain circumstances it was there to protect the company and in particular to protect the creditors. Now, the maintenance of capital has evolved because when you can only return something which you put in. But in this day and age, there are many £100 companies, and the rules on maintenance of capital have evolved so that you may only pay money to shareholders in certain specified ways. And unless you do it in certain specified ways, i.e. out of money which is the shareholders, profits which have been made in the business, it's not the shareholders' property and not liable to be distributed to them. And so that's where we are with maintenance of capital. So one looks now at unlawful distribution as opposed to strictly return of capital. And that's why we say that the modern law really is encompassed in Ridge, and that's where it's been taken through. And it can really be described in this way, at least the common law aspect of it, and that is a shareholder may not take money out of the company. It's best to use that neutral phrase, take money out of the company as a shareholder, and it of course has to be qua shareholder unless he's entitled to do so, unless it's effectively his money, i.e. it's profits which have been earned in the business and which are therefore capable of distribution, distributable profits. And of course, this common law rule, and Aveling-Barford is about the common law, entirely chimes with the statutory provisions, which were, there have always been statutory provisions for that dividends or distributions can only be made out of distributable profits, but they were enhanced at the behest of the EEC and the coming in of the second directive, because there was some always some argument about how you would work out what the distributable profits in fact are. So what was then brought in by the Companies Act 1980, giving effect to the EC second directive, were provisions for accounts, so you would actually work out what those profits are. So the regime, the statutory regime, became a little bit tighter. So if we go to Ridge Securities, now I'm not going, your lordships may be pleased to know, to try to explain this very complicated tax scheme which Ridge Securities came up with. And if your lordships look at page 481, it comes case stated from the commissioners, and the following facts, it says in the middle of page 481, are in the main those referred to by the judge in the course of his judgment. Certain additional facts have, however, been added, which, in view of its great length, in the case of the case stated, haven't been reproduced in full. But essentially, as your lordship see from the end of the next paragraph, there were 3 series of related transactions. The first involved the purchase of certain companies. The second, which is on page 482, about halfway down.
Do we really need to go into all that? I mean, it's concerned with dividend stripping operations under a totally different system of taxation than what we have now. That really, if we're going to finish in a day, I really don't think we should go into the archaeology.
No, my lord, indeed. And having dealt with various arguments about whether it was a matter of trade and whether it was, in inverted commas, properly interest, we come to the main point, which is on 495. Because Mr. Foster for Ridge, the taxpayer, had an alternative argument, but Mr. Magnus for the revenue in the break at 495 raised the contention, and these were the so-called interest payments, and it's already been decided that there was nothing to do with interest. These weren't interest payments, properly so-called at all, because they were such huge amounts of money. So Mr. Magnus says that the payments were ultra vires, the interest payments were ultra vires, the 4 companies, and they were from the 4 subsidiaries to the parent company, Ridge, and as such had no legal operation. And Miss Justice Pennycook says that this contention is well-founded and provides the real answer to the question. The Special Commissioners found that none of the companies had any reason to issue a debenture unless Ridge caused it to do so, and that those particular of the 2 companies had no reason at all for borrowing, and the terms of each debenture, the so-called interest, represented in fact a gratuitous disposition of an enormous sum by the company concerned in favour of Ridge, by the subsidiary in favour of the parent. On these facts, and in the absence of any further material, it seems to me to follow that it wasn't within the powers of the company to enter into the covenant or make the payment. And then this is the passage which is oft cited. A company can only lawfully deal with its assets in furtherance of its objects. Corporators may take assets out of the company by way of dividend, leave of the court, reduction, or in a winding up. They may not acquire them. They may, of course, acquire them for full consideration, but they cannot take them out by way of voluntary disposition, however described, and if they attempt to do so, it'll be ultra vires. Now, pausing there for a moment, there are a couple of points on this important passage. The first is that in my submission, the words "taking assets out of the company" is much the best description, and it has, of course, to be qua corporator, qua shareholder. I see in the paperwork that my learned friend has raised the prospect that if a shareholder in Asda goes into a supermarket and sees that they've mispriced an expensive television, they've got the decimal point in the wrong place, so they're selling £100 instead of £1,000, and he takes advantage of this. If it's a bargain that Asda can be held to, my learned friend says, well, can this possibly be a distribution? Well, of course it's not, because he's not buying or acquiring the television qua shareholder. He's acquiring it qua customer. And so there has to be a degree of objective assessment on all the facts in relation to these things. So it has to be qua shareholder. And of course, the reason for that is that shareholders control companies, and they are the ones who can procure the actions on the behalf of the company, and they can therefore procure payments to themselves unless it's prevented. And that's why we have these rules on maintenance of capital, and why also it's ultra vires, and why also an ultra vires act of that sort can't be ratified. Otherwise, the shareholders would have their own means of exoneration of their wrongful acts. Now, the other point that, and of course, we're not dealing here with a capacity point of ultra vires. We're not dealing with, as many of the cases were, whether the act complained of comes within or without of the memorandum of association. So, for example, in one celebrated case, reintroductions in 1968, a company got into terrible difficulties because it had carried on the business of, I think, it's something to do with the tourist industry, and that's what its object was. And then it decided to go into pig farming. And there was no way that you could squeeze the object of pig farming into the memorandum, and so the whole of its business had been conducted ultra vires. We're not into that territory. We're into simply the territory of unlawful distributions out of capital, shareholders taking money from companies. And the other point I wish to make on this page is in reference to Lee Behrens, because Lee Behrens is a well-known case, and your lordships see at the bottom of the page the three pertinent questions which were posed by Mr. Justice Eve as to the propriety of transactions. Is a transaction reasonably incidental to the carrying on of the company's business? Is it bona fide? And is it done for the benefit and to promote the prosperity of the company? So often one just simply uses the phrase bona fide in the interests of the company. Now, there was a great debate as to whether this Lee Behrens test about the exercise of a power actually rendered a transaction, or rendered the exercise of a power which resulted in a transaction which was contrary to these tests ultra vires or not. But that debate has been put to rest, and we're not in that the Lee Behrens test has no place in ultra vires, because what it is, that is about whether a power is being abused. And that does not mean that the matter is ultra vires if that power is abused. In a way, the maintenance of capital is a special form of ultra vires, whereby it is simply not possible for shareholders to take money out of the company to which they are not entitled. And of course, it may involve an abuse of power, but it does render the transaction an ultra vires transaction, whereas other transactions that there may be, and we've got examples in the authorities of abuse of power, doesn't render the transaction ultra vires. It may render it capable of being set aside or something of that sort, but it doesn't render it ultra vires. So Mr. Justice Eve's test does not assist. The last point that I'd make is that, having just reminded your lordships that we're not dealing here with a capacity case, we're not dealing with the sort of reintroductions type position on the memorandum. In fact, with the introduction of the Companies Act 2006 and the changes that there have been to a company's constitution, ultra vires will, in company law, be confined in the future to matters of unlawful distribution, because a company is no longer required to have a memorandum of association in the old form. Under the new provisions, the memorandum of association, and this is section 10 of the new Act, is merely a document, really more like a subscriber document, and it then becomes of mere historical interest in the constitution of the company. The company's constitution is defined in the new Act as its articles and any resolutions as to how it conducts its business and so on. And therefore, a company now will have really an infinite capacity as a legal person. But the only thing it won't be able to do is unlawfully to return or to distribute its capital to shareholders. Now, my lords, that's Ridge. The next case on the list is Halt Garage, and that's at the end of volume 1, and this is an important case. And here I would, if I may, like to spend a little time on this. The other authorities we can take much quicker. So it's tab 16 of volume 1. This was a summons by a liquidator following the collapse of the company, Halt Garage 1964 Limited, and we see from the from page 1019 that what the liquidator was seeking was the return of remuneration which had been paid to Mr. and Mrs. Charlesworth, who were the directors of the company. Now, if we look at page 1020 at D, Mr. and Mrs. Charlesworth from 1964 until January 1967 built up the business of this garage with considerable success. And but then, if we look over the page at 1021, in February 1967, this is just below A, Mrs. Charlesworth was sadly taken very ill and had to go to hospital, and she never returned to the business. And in December 1967, she and her husband moved to the Isle of Wight for health purposes, and then, as it says, no further part in running of the business. Then it said that Mr. Charlesworth, throughout 1967, right up until when they moved, he devoted his time full-time to the business. They then sought a buyer for the business, but this didn't come about. And at H on this page, 1021, Mrs. Charlesworth being completely out of the picture at this time, although she remained a de jure director, Mr. Charlesworth continued in overall charge until the end of September 1970, when this poor gentleman suffered an accident. And on page 1022, the profitability of the business was declining, and between B and C, in the following year, 68 to 69, things took a decisive turn for the worse. There were some roadworks on the motorway or impeding access to the garage. And so, between D and E, there was a heavy trading loss. Just below E, unaudited accounts for 1970 showed that the losses still continued, but Mr. Charlesworth still hoped to pull it around. And then there was a potential sale, but that didn't come about. And his lordship then concludes at 1023 that those were the salient facts, and the liquidator now seeks to claim the remuneration which Mr. and Mrs. Charlesworth took from January 1968 onwards. At C, the submission of the liquidator was that the payments made to Mrs. Charlesworth from the date on which it was known that she was incurably ill and wouldn't return, and the payments made to Mr. Charlesworth, insofar as they exceeded a reasonable amount, which was put at £30 a week, were simply gifts from the company, which the company had no power to make and which it could not therefore be ratified by shareholders. And then his lordship says that between F and G on page 23 that sympathy has no place in his consideration. And the counsel for the Mr. and Mrs. Charlesworth takes his stand on the fact that the company has, by its constitution, an express power to pay remuneration, and it was voted, and that is an end of it, especially as there was no suggestion of bad faith. And at page 1024, counsel for the liquidator concedes, this is at E, that the remuneration was formally determined, and in any event it would have been determined informally by the duomatic principle, but he argues that those determinations were ineffective as far as they purported to sanction or ratify payments to Mrs. Charlesworth or excess payments to Mr. Charlesworth, either because they were ultra vires or, if not ultra vires, such as were on the authorities incapable of ratification.
Sorry, where was that?
This is starting at E, my lord, on page 1024.
Yes.
We're going back to...
Yes, I have it. Yeah.
Yes. And he refers that it was Mr. Blackburn for the liquidator. He refers to the ultra vires point, and it goes on at just above G. The shareholders acting as a body and subject to the rights of minority may, he submits, make a disposition as they think fit of that part of the funds of the company which consists of profit available for distribution by way of dividend, but when profits have been exhausted, so the company is dealing with its capital, whether share capital or loan, any disposition of the company's assets otherwise from consideration, and whether made by directors alone or directors acting with the sanction of a general meeting, must and then it gets on to satisfying the three tests in Reilly-Behrens, which we see later is a red herring. His lordship then analyses a case called Hutton and Westcourt Railway from the top of page 1025 onwards, which was a case in which remuneration was paid to directors for past services, and Lord Justice Cotton and Lord Justice Bowen held that that was recoverable. Lord Justice Bagley dissented, and the approaches of Lord Justice Cotton and Lord Justice Bowen were different. We see at E on page 1025 that Lord Justice Cotton's approach was to consider whether what had been done was intra vires in the true sense of the term, and so on. But then he concluded that it was nevertheless wrong. And then Lord Justice Bowen's judgment on page 1026 is referred to at G, and he really went on the basis of the binding of a dissentient minority. But in particular, at page, what's called the classic cakes and ale judgment, I think it was, that's a reference to if the directors of a company want to send their employees out for cakes and ale, why should they not be allowed to do so if it's bona fide in interest of the company and keeping on good employee relations? 1027 is an important passage because it's one that's picked up in subsequent authorities, albeit it's done in the context of a majority binding a dissentient minority. But what is said in that passage on 1027, cited by Mr. Justice Oliver between B and D, is bona fides, just below C, cannot be the sole test. Otherwise, you might have a lunatic conducting the affairs of the company and paying away its money with both hands in a manner perfectly bona fide, yet perfectly irrational. The test must be what's reasonably incidental, and so on and so forth. Now, his lordship then deals with, comes on to Reilly-Behrens on page 1028 at between E and F. And he deals with Reilly-Behrens and the authorities following in some detail. But if I could go on to page 1029, what his lordship says, and this is where the explanation of Reilly-Behrens first comes from, which is subsequently taken up by the Court of Appeal in Rolled Steel. At G, I confess I haven't found it easy to understand the logical basis for the doctrine in Reilly-Behrens as it was applied in that case and has been applied in subsequent cases. It's frequently spoken of as a facet of ultra vires, but I doubt whether that's strictly correct. If it were, it would involve this, that every power, express or implied, would have to be read and qualified by some such words as if, but only if, it's for the benefit of the company's business and so on. If that has to be read into every power, it's difficult to see how the company could ever declare a dividend which must necessarily reduce the assets. I cannot help thinking, if I may respectfully say so, that there's been a certain confusion between the requirements for valid exercise of the fiduciary powers of the directors, which have nothing to do with capacity, but everything to do with propriety of acts done within that capacity, the extent to which powers can be implied or limits placed as a matter of construction on express powers, and the matters which the court will take into consideration at the suit of a minority shareholder in determining the extent to which his interest can be overridden by a majority. These questions, he says, raise questions which are logically quite distinct, but which have sometimes been treated as if they demand a single universal answer, leading to the conclusion that because a power must not be abused, therefore beyond the limit of propriety, it does not exist, i.e. ultra vires. It cannot, I think, be doubted that whether it be logically defensible or not, and whether it be laid in application ultra vires or the protection of minorities, the courts have evolved a series of principles, and then he goes through it. Essentially the conclusion which is drawn is that the Reilly-Behrens test has nothing to do with ultra vires. The abuse of a power doesn't mean to say that you don't have the power, it just means you get relief for abuse of the power. And then further authorities are dealt with, Charter Bridge and Park and Daily News. But his lordship returns to the theme, which is closer to ours, at page 1032. And what he says between E and F on page 1032 is that Charterbridge, which was part of the Reilly-Berens debate as to ultra-vires, which has now been put to bed. It does not appear to me, says his lordship, that the Charterbridge case assists very much in the present context. It does not, as I see it, relate to the distinctive principles which the courts have established in relation to gratuitous dispositions of companies' assets. And then picking it up again at the between G and H, his lordship refers to Charterbridge again, but then in particular Ridge, and refers to Ridge Securities. And over the page at 1033, his lordship cites that passage from Ridge, which is the well-known passage which I went to in Ridge itself. And then he goes on after that at 1033 at C. Counsel for the liquidator hasn't been able to point to any reported case in which the principle has been applied to the determination of payment of directors' remuneration. And I was at first rather startled by his submission, which seems to me to have surprising and far-reaching consequences. If it is really the case that such a payment is ultra-vires, unless it be, whether viewed subjectively or objectively for the benefit of the company to promote its prosperity, then it must logically be ultra-vires from whatever funds the payment is made, and whatever the company's financial position. But it's commonplace in private family companies, where there are substantial profits available for distribution, for shareholders, directors, to distribute the profits by way of remuneration rather than dividend, because it's fiscally advantageous. But such a distribution may infrequently does have very little relation to the market value. And if one's to look at it from the point of view of benefit, then it's wholly unjustifiable because it deprives the company of funds. Now, pausing there, of course, what happens in this case, and all cases, is that if there are distributable profits, it doesn't matter on what basis the shareholders take the money out, because they're entitled to that money. It's only if there are not distributable profits does it matter on what basis the shareholders take that money out. And if they are taking it out as a shareholder, and there are no distributable profits, then it's ultra vires. Then he returns to Reilly-Berens at F again, and I don't think I need to go back to that. He refers to George Newman and then concludes at 1034 at D that George Newman case appears to support the submission of the Liquidators' Council. And when it comes to paying gratuities out of profits, there's no necessary requirement of consideration of the interests of the company. Indeed, because the profits, the people who are entitled to the profits are the shareholders. The shareholders may do as they please. What they cannot do, at least without the leave of the court, is to return capital to themselves. So he then continues and deals with the point about divisible profits. And he says at the bottom of the page that in the last three lines, the test of bona fides and benefit to the company seems to me to be appropriate, and really only appropriate, to the question of propriety of an exercise of the power rather than the capacity to exercise it. And of course, that's where we're getting back to a capacity point, because there is no capacity to exercise the power to make a distribution where you have nothing to distribute. And then he refers back to some authorities and introduces Greenhalgh on page 1035, but picks it up again between F and G. The true rationale of the cases is not what was proposed was ultra vires, but that they were concerned with a different question, namely the circumstances in which the court will interfere to prevent the majority from overriding the rights of a dissentient majority. And that's where we come to the point about explaining the abuse of the power as opposed to exercising a power which you simply don't have. And that is what we then turn to at page 1037, which is at F, and he refers again to Ridge Securities at F, illustrating the proposition. And at 1038, he says that when Mr. Justice Pennycook referred in that passage to the corporators taking money out, he was referring to payments to them qua corporators, and I don't think for one moment he can have had in mind the payment of directors' remuneration as a result of a vote passed in accordance with express provisions of the company's constitution. But in the context of the instant case, Mr. Blackburn submits that since there were no profits available for distribution, and since directors' emoluments are always gratuities except where payable under contract, and since the directors were shareholders as well, every payment to them constitutes an illegal reduction of capital to the extent, unless it can be justified by the test of benefit to the company. And he accepts the submission of counsel for the liquidator the gratuitous payment out of the company's capital to a member qua member is unlawful and cannot stand, even if authorised, because, of course, you can't authorise an unlawful act, an ultra vires act. What I find difficult in accepting is assuming some to be genuinely paid, whether there's some further test. And then there's a discussion about directors' remuneration is not payable merely out of divisible profits if they're shareholders. No, of course not, because what would then happen is if a company is in difficulties, but it has every prospect of surviving, the directors would be in difficulties if they're shareholders in paying themselves any remuneration. But in those circumstances, if they're paying themselves reasonable remuneration in the circumstances of the company, there's no element of distribution or anything like that, because what's actually happening is they're being paid remuneration qua director, not qua shareholder. But that wasn't the position in relation to this company, because we'll come on now to His Lordship's analysis of it. At page 1039, at B, what I think counsel's submission comes to is this, that while the company has divisible profits, remuneration may be paid on any scale which the shareholders are prepared to sanction within the limits of available profits. But as soon as there's cease to be divisible profits, it can be only lawfully paid on a scale which the court, applying some objective standard, considers to be reasonable. And then, and bona fides can't
I'm sorry,
be.
I haven't picked this up.
That's at 1039,
Yes.
between B and C.
Between B and C, sorry, yes, thank you.
Objective standard and reasonableness. And then there's a reference to bona fides not being an answer, not least of all because at D, one would have Lord Justice Bowen's lunatic director defence, namely that a lunatic director would be able to do anything he liked, because if bona fides were the answer, he would be bona fide. So he comes between E and F to the real question. I don't think that in circumstances such as those in the instant case, the authorities compel the application to the express power of a test of benefit to the company. That's the Reilly-Barron's point. The real test, he says, is whether the transaction in question was a genuine exercise of the power. The motive is more important than the label. Those who deal with a limited company do so on the basis affairs will be conducted in accordance with its constitution. And one of the express incidents of that is that the directors paid remuneration. But subject to that, they're entitled to have the capital kept intact. Maintenance of capital. They have to accept shareholders' assessment of the scale of REM, but they're entitled to assume that whether liberal or illiberal, what is being paid is genuinely remuneration and not the cloak for making payments out of capital to the shareholders. And of course, one way of ascertaining it may be to look at Reilly-Barron's, but those are just indicia, not the test. So he turns to the facts of the instant case on 1040 between A and B, and he first deals with Mr. Charlesworth, and he finds, and of course this was a case of which would engender sympathy on the part of Mr. and Mrs. On the part of anyone towards the plight of Mr. and Mrs. Charlesworth, and there was no question of mala fides on their parts, and he comes to the conclusion that the payments of remuneration to Mr. Charlesworth were appropriate, because of course what the court won't do is seek to second-guess commercial or managerial decisions on the part of the company. But by that same token, you can't hide behind a cloak of commerce or management for the reduction of capital, unlawful reduction of capital, or return of capital to shareholders. And he then comes to the position of Mrs. Charlesworth at page 1041, just below D. He says he feels considerably greater difficulty over the payments to Mrs. Charlesworth. If it's contrary to the view I formed, it would be right to apply the test of benefit to the company. It is very difficult indeed, this is at E, to justify the payments by any rational application, and it would follow that the Directors' Act in paying them couldn't be ratified. It should perhaps, and then this restricts the liquidator's payments to after 30th of April 1968 because there were distributable profits at that point, so she could take them out qua shareholder perfectly well. But after that, there was no profit to be distributed, and Mrs. Charlesworth rendered no assistance to the business because she was ill and confined to the Isle of Wight. And that's what's then said at just below G. But then his lordship does note that she remained a de jure director, and he does in fact give her some remuneration for the office of director. But when he comes, and that's a little bit later on, and but at page 1042, between F and G, he refers to remuneration again, but he says the real question is whether the payments really were directors' remuneration or whether they were gratuitous distributions to a shareholder out of capital dressed up as remuneration. And then he refers to the mere holding of office. But counsel for the liquidator in relation to that says, between H or just above J, that the sums paid to Mrs. Charlesworth were so out of proportion to any possible value attributable that the court is entitled to treat them as not being genuine payments of rem, but as dressed-up payments, dividends out of capital, just like the dressed-up payments of interest in Ridge. And again, he says there's no fraud or mala fides. And he then, at page 1043, deals with that point a little bit more. Just below B, no intention to defraud, but that can't be conclusive. Just above C, the real question is were these payments genuinely directors' remuneration? If your intention is to make a gift out of capital of the company, you don't alter the nature of that by giving it another label and calling it remuneration. And the court is not he says it between C and D, a slave to whatever form of words. And he concludes at E that the court is not precluded from examining the true nature of the payments merely because the members choose to call them remuneration. And then he finds at between H and I that it's impossible to hold that the whole of the sums of Mrs. Charlesworth's remuneration of £1,500 a year were directors' remuneration in any real sense of the word. And he concludes that in truth, at the bottom of the page, from 1st of April 68 onwards, they were paid out of capital, and they were, which so far as any rate they exceeded anything which could reasonably be called remuneration, for acting merely as a director. The office of director, the company had no power to sanction. And he refers to pure gift, again, in the next paragraph. And he then, between D and E, his lordship refers again to a liquidator's submission that the entirety of the payments to Mrs. Charlesworth are recoverable, but his lordship feels unable to accept that. A sum paid simply for the assumption of responsibility of being a director is properly described as remuneration. The difficulty must necessarily be know where to draw the line, what reasonably described as genuine reward and what could not. Remuneration doesn't cease to be remuneration because it's generous or even perhaps unwisely generous, but there's an obvious difficulty about fixing any point. But in the absence of any evidence of actual motive, the court must, I think, look at the matter objectively and apply the standard of reasonableness. And so what he does is he assesses the reasonable sum for the office of director of £10 a week, which is obviously just over £500 a year, and Mrs. Charlesworth was getting £1,500 a year, but the remainder is recoverable as an ultra vires payment, and that's what he concludes between H and J. So, what was happening there was, in my submission, his lordship was plainly analysing the situation objectively as regards Mrs. Charlesworth. And, of course, it was important that one looked at the entire facts, because here one has always to work out whether the payments are being made qua shareholder, as opposed to qua company or qua director or something of that sort. But if you look back at page 1043, and I only refer to the bottom of the page, it was interesting because at J, his lordship said, the payments were, as it seems to me, simply a recognition that as a co-proprietor of the business with her husband, she ought to be getting out of the business what she had before, and that director's remuneration was a convenient label. So they owned the business. They were husband and wife and really co-partners in the business. And she just continued to take out the money as before, called remuneration. But what his lordship did, and of course, when you've got plenty of money in the company, it doesn't matter. If you've got distributable profits, you can take them out. It doesn't matter what label you attach to them. You can do it in a fiscally advantageous way. But when you don't, it certainly does admit of an objective assessment as to reasonableness. And when his lordship deals with motive on page 1044, at the bottom of the paragraph at F, when he says, in the absence of any actual motive, the court must, I think, look at the matter objectively. In my submission, motive is merely one of the circumstances which the court will take into account. And I think what his lordship means there is bad motive. If it could have been said that there was mala fides on the part of Mr. and Mrs. Charlesworth, and they had cooked up the payment of remuneration, and they knew it to be outlandish to Mrs. Charlesworth, simply to get money out of the company ahead of creditors, that would obviously have told very rapidly, and his lordship may not have had such a struggle getting to the conclusion that he did, or at least been able to cut through it rather more quickly. But the point is that there was no bad motive, but they nevertheless got it wrong.
The analysis of bad motive is, I find, rather tricky on this factual scenario. It seems to me knowledge that one is doing something improper is really what he's talking about.
Yes, I think
because
that's...
there was knowledge that Mrs. Charlesworth was being given money when she'd rendered no services.
Well, there was... This goes to a debate which is featuring more and more in the law reports with this point about objective honesty or objective dishonesty. And that is, if you know all of the facts, it doesn't matter what your own view of honesty or director's propriety is, it will be judged objectively, and you'll be subject to that objective, reasonable assessment. That's right.
Mrs. Charlesworth, of course, was a recipient, but the way the liquidator put it was that she and her husband were guilty of misfeasance and breach of trust.
Yes.
And also, at D on 1044, it's not treated as a recipient liability, it's treated, I think, even though the expression ultra vires is used, it's treated as director's liability.
Well, of course, by this stage, the really Berens point was very much to the fore. And indeed, I may have, in this case, if we ever come on to the pleadings, slightly fallen into that trap myself, although it was absolutely obvious at every stage to my learned friend and the tribunals below that this was my case is based on what is really the Aveling-Barford principle. But this really answered the point in his lordship's incredibly thorough judgment about really Berens, and the decision in this case is, in my submission, clearly that it was an ultra vires payment, not least of all because if it wasn't, they would have ratified it, and they had ratified it all as remuneration. And of course, the only way that this was recoverable by the liquidator is because that ratification was a nullity, because you can't ratify an ultra vires transaction. So that's really what it has to be, and certainly.
Couldn't she be treated as constructive trustee? It wasn't put on that basis at all, was it?
No, it wasn't. It was put on a much more a classical company law basis, if you like, with a slight confusion with really Berens, I accept.
Well, it's put on basis of breach of duty, really, isn't it?
Well, it is, but of course, what his lordship says, and indeed what counsel for the liquidator says, is that they are that the amounts above a reasonable amount for the office of director, the difference between £500 a year and £1,500 a year, are effectively paid out of capital, and that's because of the analysis of the way that it's done. And in
I'm only asking this simply because here I'm not quite sure on what basis your pleading says that Moorgarth Fold Free is liable, but it's either on the basis it's void, and therefore,
Well, it's an ultra vires act.
yes, and therefore you're entitled, or you also put it in paragraph 22 on the basis of knowing receipt, probably, don't you?
Yes, I
And
do.
that's gone, is it?
Well, if we look at Aveling Barford, that of course is one of the ways in which, because one has to have the relevant degree of knowledge, because this was not in the case before your lordships, this was not a distribution to the shareholder Tradegrow. It was distribution to another subsidiary of Tradegrow, which is Fold Free, now Moorgarth. But that made no difference, and that was exactly what had happened in the Aveling Barford case. It wasn't a distribution to the shareholder in Aveling Barford, it was a distribution to one of the creature companies of the shareholder. But that, of course, makes no difference. It is taken to be a distribution to the shareholder. And that's certainly what's been accepted in this case, which is why we come to your lordships on the sole point as to whether the director who procured all of this, not having a guilty mind or a bad motive or however it's framed, but believing that he's doing the right thing, provides a complete exoneration, even in circumstances where we say that if you apply any objective test of reasonableness, it falls down.
That's not quite how I read the Court of Appeal. We'll get to it later.
Yes,
but,
we will.
As I see it, they look at the transaction and say, contrary to what Mr. Justice Oliver thought here, that it could be categorised as a legitimate transaction overall.
Well, you see, one doesn't, in these circumstances, need to characterise transactions as shams or something of that sort. And that's not how his lordship in Hall Garage, I mean, his lordship didn't say that the remuneration to Mrs. Charlesworth above £500 a year was a sham or anything like that. He didn't use such language. He just said that in the circumstances, what actually it boiled down to was them taking money out as corporators.
There was nothing in return there, basically. She did.
That's exactly right. A gratuitous disposition of the company's property.
The argument here would be that either, I think we probably must assume the contrary to this, but one view might be that the company didn't have worth more than 8 million because these repairing covenants were in fact worthless. But
Well,
let us assume that it was worth 12
yes.
million. Then the argument would be that PPC
Made a bad bargain.
no, it didn't, because PPC would have gained a windfall and had to, in one way or another, credit that against the price which it got for YMS1 and YMS2. And that's why the price was, in fact, reduced, because no one was contemplating that PPC would manage to walk away with the value of a subsidiary, which was supposed to lie in these beneficial repairing covenants, when these had been nothing more, the repairing covenants, than a gift made some time before. And
Well-
the whole transaction wouldn't have gone through if the price had been 4,066,000, would it?
Well, the transaction would certainly have been would have had to have been structured differently. But of course,
would it have made any difference, supposing the contract between PPC and Moorgarth had said the price is 4,066,000, against which we're setting the 4 million, which you owe us, because it's always understood that you'll be crediting us.
but you see, there was no 4 million to set against, because it was quite clear that the counter indemnity which PPC had been said to have given was simply non-existent. That was the point. There was.
Well, it's very difficult to say it's non-existent when it's actually recited in the
Yes.
in the documents leading up to the agreement, isn't it? And virtually recited in the agreement itself.
Oh, indeed, it is recited. But that, of course, is all part of the that's all part of the misunderstanding. And indeed, what the agreement recites and the deed of release recites is something which is non-existent. It's releasing something which is simply not there. And that's what his lordship held at first instance, that there was that not only did this liability not exist, and there were and my submission was that no reasonable director could have thought that it would have existed. But his lordship didn't need to go on to deal with that, because his lordship said that the fact that this director, reasonable or not, thought that it did, was an end of the matter.
Does that mean that if someone wrongly thinks that a director is worth £1 million a year because they perform very beneficial work, but in fact it's misguided because they've entered into a whole lot of extremely vulnerable derivatives contracts or something, then you can say the transaction's ultra vires because you can see actually that this was all a mistake in valuing the remuneration to that level?
I'm sorry to give this answer to your lordship, but it depends. The question of remuneration, I mean, first of all, one has to know whether the director is just simply a director or also a director and a shareholder, because the ultra vires aspect only refers to a shareholder. But let us assume that there is a director and a shareholder, and it's a hedge fund which has been involved in transactions which have turned out not well. But the remuneration, if paid according to the at least, well, perhaps still current remuneration rates of hedge fund operatives, would perhaps appear outlandish. But if that's being paid and it's thought that that's what that person is worth, then he is being paid qua director. He's being paid director's remuneration. However, if what's happening is post Lehman's, there's been a bit of a change, but that the remuneration which is being paid in circumstances where the company is in really grave difficulties is still outlandish. It could well, depending on the circumstances, when viewed objectively, amount to an unlawful distribution to that person, because what it could be being said is that he is not taking out remuneration, properly so called. What he's actually doing is taking out a dividend from his company, and he's just dressed it up as remuneration. So it all does depend, I'm afraid, on the circumstances. So he could end up as a Mrs. Charlesworth. But it does, of course, depend. Now, Mr. Charlesworth was taking money out of the company, but he was doing a job for it, and it was still coming out of capital, and he was still a shareholder. But that was not to be upset, because he was taking it out qua director. Mrs. Charlesworth was taking out £500 qua director, but £1,000 qua shareholder, and that's how it was, and that's how that matter was upset. And of course, what we say is it doesn't matter how you, as Mr. Justice Pennicook would say, take money out of the company. You can take money out of the company by way of a gratuity. You can just simply take it, and this is what was talked about in Hall Garage. Or you can take money out by way of, and it quite often happens this way, a transaction at a gross undervalue. You still have to take money out qua shareholder. I gave the example in the statement of case of corporate reconstruction involving a gold mine, involving a barren mine, in that the directors of a mining company decide to have a corporate reconstruction and to offload, to clean up their balance sheet, to offload barren mines. And one of the shareholders, and it's all done qua shareholder because it's done in a very, there's no outside people involved. It's almost a distribution in specie to the shareholder of these barren mines. And they take a valuation, they get a geologist to look at it, they get a valuer, and they say, indeed, it's a barren mine, it's worth very little money, you pay that and you take it away. Now that's simply a sale. It doesn't have any of the hallmarks of a distribution as a shareholder. But if ultimately some new mining technique renders it to be literally a gold mine and not a barren mine, then that shareholder benefits. But the position we say is very different. If the transaction is done in a slapdash way by the directors of the mining company, and they say, oh, look, it's probably barren, let's not bother to check it out. You just take it off our hands at book value, which is virtually nothing, and we won't check it out. Now, that's one end of culpable. A middle culpability might be, well, we're a bit suspicious about this gold mine, but I tell you what, let's just keep quiet about it. Almost blind eye knowledge, but not quite. Or they've actually got a report from a geologist and they overlook it. It's on their desk and they just forget to look at it. And then, of course, at the other end of culpability would be actual knowledge or blind eye knowledge leading to actual knowledge. But wherever you are on that, wherever you are on that scale where there's culpability, in my submission, it is to be assessed objectively, according to all the facts. I mean, it cannot be right that a director who is grossly negligent can obtain for himself as a shareholder or for his creature company a benefit, and then seek to say, oh, don't worry, it's all been ratified, and you can't go behind the ratification, because, of course, it's the inability to ratify an ultra-virus transaction which is absolutely critical.
You haven't yet shown us any authority which says that the culpability of the director is of the essence of the question of whether or not the transaction is ultra-virus.
Well, I have, I think, because of Holt Garage. And this was a case in which there was, as it were, I mean, it was at the lower end of the culpability scale, because there was no question of mala fides or anything of that sort. But the fact is that the payments that were made to Mrs. Charlesworth in excess of her reasonable remuneration were, in the circumstances of this case, to be characterised as effectively her taking dividends out of the business like she always had. And they gave no thought to, they just took the same amount of money out of the company. And so to that extent, she was culpable. And indeed, Mr. Charlesworth was culpable as well.
Can I just ask a question which leads into that? We're talking in terms of the common law.
Common law principle, yes.
You've helpfully put in your authorities the statutes.
From the 80, yes.
The relevant one being the 85 Act at
Correct.
the time.
And there's no difference to the 06 Act. It's been moved around a bit, but the wording and terminology is exactly the same.
Except in the intergroup transfers.
Correct, except for that
do it at
Aidling
book
Barford,
value. Yeah.
yes.
But there's some, we also put in the Company Law Committee reports which show there's some doubt about actually or the scope of the Companies Act 1985
yes.
provisions about not making a distribution except out of profits.
Yes.
But you don't contend that this is within the Companies Act provisions, presumably because those provisions are confined to amounts stated in the accounts.
That's right. In this case, not only were there, possibly not even the relevant accounts, but it's never been a contention that there were any distributable profits whatsoever. So
I mean, as a matter of interest, we don't know at what value YMS 1 and 2 stood in the accounts of PPC, do we?
No, I'm not sure we do.
No, it's rather strange. But can I just ask, if one were to look at the Companies Act scheme,
yes,
Section 277 actually might lend your general proposition some support that it's not just knowledge, it's tab 1,
tab 1, page 11, Lord. Yes, indeed.
It's not just knowledge, it's knowledge or reasonable grounds for believing that you're distributing out of profits.
Well, you see, that's in relation to a recipient.
Yes, I see. Doesn't the same principle apply to the validity of the transaction?
Well, we would say that however one looks at this, and whichever analogous situation of company law applies, one always looks at the position of what a director knows or ought to know. I mean, one simply always does, and therefore there is always an element of objectivity.
But, I mean, I thought your case was that we are talking about a distribution made by a company to one of its members in contravention of common law, actually.
Yes.
And at the time of the distribution, the member knows or has reasonable grounds, and I thought you said that the member here did, through Mr. Moore, know or have reasonable grounds. So
yes, my lord, that's exactly right.
If there's an analogy, why doesn't it apply?
Well, my lord, that's exactly right, and I'm grateful to your lordship, and that's why we also included...
Sorry, which bit of the Companies Act are we looking at?
With 2771, my lord.
Thank you.
Your lordship nearly had this aspect in Bairstow, but not quite. This was in relation to the recovery of distributions made to members. And for your lordship's note as well, Lord Mance, we included the most recent authority on 277, at tab 19 of volume 2, which is a company called It's a Wrap, and that's WRAP. So tab 19 of volume 2 is a Court of Appeal authority directly about 2771 and the knowledge, because what had been held by the judge at first instance was that there had to be some consciousness about it all, and the Court of Appeal said no. So it falls very much into where we are with dishonest receipt, with Barlow Cows, those sorts of authorities.
You don't have to know the law.
You don't have to know the law. And indeed, in that case, It's a Wrap. Lord Justice Sedley said, look, you people, unless it's a criminal context, people are taken to know the law. And so yes, that is a
Your case is a common law, it's not under section 263.
No.
And why is it not under section 263?
Well, I mean,
Because of section 270, isn't it? It implies that you're only dealing with distributions determined by reference to items stated in the company accounts.
well,
Is that right?
Well, in fact, I did run the point both by way of common law and statute. And Lord Justice Mummery in the Court of Appeal said it was accepted that this added nothing more, and that is indeed right. But section 263 is a standalone provision.
So why is it not a section 263 case on your analysis?
Well, it is.
So why isn't it at the forefront of your case?
I thought you said a moment ago.
I'm so sorry. It was I was dealing with 27. I was referring to.
Well, my question relates to section 263.
Well, indeed.
Is your case,
Yes.
or should it be under section 263?
It is, as well as under the common law principle. That's right. Because if you look at
So section 263 on your case represents the common law position. Is that right?
yes, it does. Yes, it does. If you look at 281 on page 12, right at the end, that's an interesting section because it saves the common law 281. It's still in tab 1, my lord. 281. Penultimate page in tab 1. So 281 preserves the common law position. There was, and indeed that is still the same under the 2006 Act. And the reason for that was that it was originally suggested by some consultees under the Company Law Review that this should be purely a statutory-based scheme, and that the statute should displace the common law entirely. But the point that was then made was that this could lead to certain anomalies in that.
None of this matters, though, if your case is the section 263 states the common law.
Well, it does, because it has always been the case, 2631, a company shall not make a distribution except out of distributable profits, and that's not a new section, that's been there for absolutely ages.
But I mean, you've got to recognise, haven't you, as the Company Law Review Committee said at tab 5,
Yes.
June 2000, paragraphs 33 and 34, this is a somewhat metaphysical area.
Yes.
It's far from clear whether section 263 is independent, as you just suggested, of section 270, and it's far from clear whether, to use the language of paragraph 34, you can conflate the statutory accounting rules on distribution with the common law rules, essentially by treating all transactions falling within the common law rules as distributions under Part 8. Apparently the cautious view of the effect of Aveling Barford, widely adopted, is that you can, but it doesn't appear to be decided that they're the same.
Yes, I mean, you're right about the metaphysical nature of all of this, and indeed the metaphysical nature of the changes in the 2006 Act, because it was all brought about by paragraph 31, which is that there's a body of opinion prompted by the decision in Aveling Barford that an intragroup sale of an asset may constitute a distribution for the purposes of 263 if the asset concerned is sold for an amount equal to its book value, where this is less than market value, even where the company has distributable reserves. So in those circumstances, even where the company could do it, it could give its money away to whomsoever it liked, because that money did not belong to creditors, did not belong to the company. They were free for distribution. It was thought that problems arose because of the Aveling-Barford principle and the way in which it had really raised the whole level of awareness of maintenance of capital. Holt Garage and to an extent Roll Steel Products never really hit the company law consciousness in the way that Aveling-Barford did, and that's why we see Aveling-Barford given its own page on the previous page, and what the Aveling-Barford principle is, and reference there to the paragraph 30, the decision being made by reference to common law rather than the statutory rules. But the fact that at paragraph 31, people were conflating the two, as indeed they should so be in my submission.
Can you just tell me, what is the basis of the common law obligation of a shareholder to repay a chunk of capital that's been wrongly paid to the shareholder?
That, I think, would pick up my Lord Collins' point about you would look to common law rules and knowing receipt of property. Because you receive, just like 277.
It's a restitutionary obligation.
It is a restitutionary obligation.
Yes. Now here you're simply saying the sale was void as ultra vires, so
yes.
It was of no effect.
That's right.
Well, what if the sale was of chattels which had been sold on by the shareholder and no longer existed? What would the shareholder's obligation then be?
It would be to make good the default. And we get that from the Criterion case, Lord Nichols in Criterion, which was a case of want of authority on the part of directors rather than an ultra vires transaction. But Lord Nichols, neatly at the beginning of Criterion, which we've got in Volume 1, just says, well, in those circumstances, if you receive that under a void transaction, you're liable for that. If you've then done something with it and you can't actually return it. But could I just go back to 263?
Yes.
And remind your lordships also that not only is there the strict nature of 2631, you can only make a distribution out of distributable profits, which is exactly the common law rule. 2632, distribution is every description of distribution, whether in cash or otherwise, every description. So that picks up also in my submission the label point. It picks up Mrs. Charlesworth's remuneration label. It picks up a sale label, whereas in fact it's a sale at a gross undervalue or something of that sort. As well,
and this was a distribution to the members?
Yes, it was. Yes, because although it went to one of the member subsidiaries, it's taken to be a distribution to the shareholder.
What at the moment I can't understand is why it should make any difference to the law that the director should have known that the sale was at an undervalue.
Well, it shouldn't in my submission.
But you've postulated in your agreed statement of facts that the director was in breach of duty. Is it simply that it's axiomatic that he's in breach of duty, even if he's not at fault at all? If he'd had a negligent valuation from a third-party valuer?
Well, if he had had a negligent valuation from a third-party valuer, and therefore he believed on a genuine basis and with no element of culpability that a particular sale to himself as a shareholder or to a creature company of his or to a shareholder was for full value. In my submission, when that's objectively analysed, that would be quite difficult to set aside. The remedy would be elsewhere. The remedy would be in relation to the negligent valuation. And so the company would have a remedy. It would have a remedy against the valuer.
It would have made a distribution of capital to a shareholder.
Yes, it would.
But
not one you can recover.
Not one you can.
Because this isn't. We're not talking here about strict liability. It's not strict liability in the sense that whatever happens, it can be returned. because that would mean that all sorts of things may get into great difficulties. My mine example, the fact that they do it totally impeccably, and years later, new mining techniques render it to be a gold mine. It would be quite wrong in my submission that could be recoverable, because it's what the position is at the time. The directors can only take a decision at the time, and if that decision is simply unchallengeable, it should stand. And so it's not a matter of strict liability, it's a matter of objective assessment, just like what Mr. Justice Oliver did, in that he looks at it objectively, talks about reasonableness all the way through his judgment and so on and so forth.
But he, when making his objective assessment, wasn't looking into the mind of the director at all. You could say an objective assessment of a disposal of an asset at half its value, objectively, is a disposal of capital to that extent.
If you like, when you look into a director's mind, it can only get worse for the director.
I thought we have recently been considering a point under Section 263 in a case called Holland against the Revenue, in which there's been some discussion of this very point. And I thought one respectable view of Section 263 at least was that a director who makes such a distribution would be strictly liable, subject to relief or possible relief under Section 727.
Yes, I think it would be. I think it would be breach. It would be.
But that would be
certainly a breach of
strict.
duty.
That wouldn't depend upon the mens rea of the director. You just ask whether he procured the distribution.
I'm not sure about that, my lord, because you can only get director's liability in two respects. The first is pursuant to his equitable duties, misfeasance, and the second is pursuant to his common law duty of care. And the common law duty of care certainly admits of a degree of objectivity, but the director's state of mind, as it were, can only make the position worse for the director. Yeah. There is, as it were, an irreducible minimum of liability from the point of view of objective reasonableness. But if the director knows or has reason or turns a blind eye or something of that sort to what's going on, then liability is going to be much easier to be fixed on him, or in relation to the transaction. But otherwise, you can't get down to the level of Lord Justice Bowen's lunatic director. Because if you have somebody who is completely hopeless and therefore completely bona fide and doesn't know anything about anything, and thinks that everything he does is perfectly all right, that really would be an extraordinary state of affairs and cut through all sorts of aspects of company, not least of all.
I don't think lunatic directors are going to help. I mean, isn't the answer to Lord Clark's point that once if you take as your starting point that it is a distribution,
yes,
and Section 263 is infringed, then there is strict liability subject only to the possibility of relief. But that leaves open the question where it's a question of something having been dressed up, whether in deciding if it is a distribution, you do have to look at the state of the minds of the people involved. And as soon as you start talking about dressing up, that suggests you do need, for some purposes, to look at what's in their minds.
I totally accept.
Yes, my question did assume that there was a distribution.
Yes, I totally accept and agree that you look at all of the circumstances. You look at all of the surrounding circumstances, and you look at the mind of the people involved. And of course,
in order to decide whether there's a dressing up.
Yes.
In order to decide whether there is a distribution.
Yes, indeed. Yes, indeed. Because you don't know. Because a distribution under 2632 is every description of a distribution. So that covers label, but it has to be of a company's assets to its members. So it has to be a distribution qua member, not qua director or qua customer or something of that sort. That's what in my submission that means.
That's begging the question, isn't it?
Of strict liability, I suppose.
No, but also whether it's a distribution. I don't think using this Latin word, whether you pronounce it qua or que, is going to help all that much, is it?
Well, although it is the way in which it has been analysed in the authorities. Certainly it was how it was analysed partly in Hall Garage, because of that passage that I went back to, where it was his lordship found that it was just a continuation of Mr. and Mrs. Charlesworth taking money out of the company as the corporators of the company and just putting on it the label of remuneration. And of course they were only doing that because they were shareholders in the company and effectively paying themselves dividends. And indeed in another case, the Macpherson case, that also was one in which the Court of Appeal analysed whether payments were being made to people for consultancy services, or really they were payments effectively, which are to be characterised and then struck down as an unlawful distribution of capital. So in my submission, it is slightly unsatisfactory. I accept this answer. But you look at all of the circumstances of the transaction in order to determine, in all those circumstances, whether it is an unlawful distribution. Of course, there are certain givens. There have to be no distributable profits. The person has to be a shareholder, and so on and so forth. But as for the rest,
the person,
the recipient.
well, this is what I was coming to. Imagine you have two shareholders. One of the shareholders is a director of the company who quite deliberately and improperly distributes a dividend out of capital to himself and to the other shareholder.
Yes.
Does the innocent shareholder have to repay?
It would then come down to it would then come down, I think, to questions as in 2771, because that is how the statutory scheme deals with the common law principle of knowing receipt or something of that sort.
It's a question of whether the other shareholder knew or had reasonable belief.
That's right, but
Grounds for believing.
Yes, but an answer to that, but that other shareholder is taken to know the law. So if, for example, the other shareholder knows all of the circumstances that would make it an unlawful distribution, for example, that there are no distributable profits, and yet he's receiving money as a dividend from the company, then he's going to be made liable, even though he's as innocent as may be, even though his state of mind is as innocent as may be. He will be fixed with liability. And that's why I said that one looks at all of the circumstances, including what is in the mind of those people who not only who procure the distribution and receive the distribution, and absolute innocence of mind and belief that everything is all right is not an answer in my submission, because otherwise Mrs. Charlesworth would not have had to have repaid her money. But of course, if you've got a much more severe set of facts, like you had in Aveling, Barford and Perrine, the court is likely to reach a swifter conclusion than the very, very careful process that Mr. Justice Oliver did, about which he was obviously troubled, but in my submission reached plainly the right conclusion in relation to Mrs. Charlesworth. Because if you have somebody turning a blind eye or knowing that something is wrong, then plainly a liability is going to be fixed very rapidly. But and of course, there may, in fact, then a shareholder may end up taking money out of the company if the barren mine turns out to be a gold mine in 5 years' time, but there's no way that that's going to be a transaction which can be looked back to and upset at the time, because everything that was done at the time was perfectly right. And in that situation, the bona fides of the directors would be an important element, together with getting proper valuations and so on and so forth at the time. But as I say in my mining example, if you look back and the bona fides of the directors are a little bit more suspect, in that they are slapdash in relation to the disposal of this mine, or they overlook the report that says, well, this might be actually a lot more valuable than in our book debts or something of that sort, then how on earth can it be right that that the state of mind of the director believing it to be at a proper value is something that one simply can't look behind? It is merely one of the circumstances. Might be more or less definitive, but not necessarily. That's why I said, as it were, the state of mind of the director's point is always sort of an irreducible minimum. And if one looks at the state of the mind of the director and it's anything other than entirely bona fide, it's just likely to make matters worse.
And this is all on the question whether there is a distribution. There is something a bit odd, it strikes me, that the question of state of mind is relevant on the question whether there is a distribution. And we wouldn't guess that by reading section 263. Because it simply says a company shall not make a distribution except out of profits, and then defines the permissible circumstances in subsection 2.
Yes, I see that.
But you aver
I do.
that distribution does, on the true construction of section 263, involve a consideration of the state of mind of the director.
As one of the circumstances.
And you get that because of you get that out not so much of any analysis of section 263, but out of the cases on the common law cases. Is that right?
Well, and I suppose as given rise with 277, because
You only get to 277.
because the way perhaps to look at it.
You only get to section 277 if there is a distribution within the meaning of section 263.
I understand, my lord, I can see that there is in fact a distribution, because if something is being distributed to members, not out of distributable profits, on the face of it, it's a distribution, and then the state of mind comes in as to whether it's a recoverable distribution
Well, that's the opposite
from that
of what you
shareholder.
said a moment ago.
Yes, but the problem.
In answer to my Lord Walker, you
Yes.
said that a distribution, the question whether there was a distribution within section 263, subsection 1, involved looking at the state of mind of the director.
But I can see that point, as it were, for the strict position. But in my submission, my previous averment and my answer to Lord Walker is the correct one, because because there still has to be a distribution, and although distribution means every description of distribution, it doesn't actually tell us what a distribution itself means. It tells us what it might include, but it says it means every description of distribution. We don't get a further definition of what a distribution is. And in my submission, and it's a distribution to members, and the way in which one looks at all of this is that there does have to be what is a distribution to members, and therefore, if somebody who happens to be a member also receives remuneration as a director, it would be a misnomer of the word, of the expression, a distribution, and especially a distribution to a member, to say that somebody who happens to be a shareholder but is also a director and receives remuneration is, if there are no distributable profits, having distributed to that person, there is a distribution to him as a member. It's not. It's payment of remuneration as a director. And that's why this is not just a mechanical phrase, a mechanical provision in my submission. And that is, and that does chime with the common law, because the common law on Mr. Justice Pennicook's formulation, which is what has been followed through, is a shareholder taking assets out of a company as a shareholder.
If one, again, descends to the facts of this case, clearly Mr. Moore, however careless you say he was in thinking this, didn't think there was being a distribution. He thought that PPC had to give credit in one way or another effectively for the value of the repairing covenants, whether that's because they were getting the benefit of a release, or which rather illogically was treated as affecting the value of YMS1, yes, or however. So yes, he thought that there was a very good reason why he should only pay, or Tradegrow and Moorgarth should only pay £66,000. Well, you say that's all wrong because if you look, he ought to have known better, and if he'd known better, you say he would have recharacterised it as a distribution, or it would objectively be. But your client, Mr. Price, has been found by the judge to have known the actual facts and to have known perfectly well that there wasn't any counter-indemnity, that PPC didn't need to be released from anything because it wasn't under any liability. So on his case, he you say, must have known very well that there was a distribution, and yet he didn't object in the slightest at the time. He allowed the transaction to go through, presumably because he didn't think it was a distribution, presumably because he thought it was a perfectly ordinary commercial transaction.
Well, of course, I have to, certainly for present purposes, accept what the judge said about my client. And indeed, if we are talking about an unlawful distribution, it becomes quite irrelevant, because all of that merely goes to ratification, and you can't ratify an unlawful distribution because it's ultra vires.
No, but it goes to characterisation. I mean, if Mr. Price thought that he was being paid far less than he should have been, there was, in other words, that PPC was effectively distributing part of its capital for free, he would have barked at the time, and the judges found that he knew perfectly well that was what was happening, and presumably the reason is that he saw it as a perfectly ordinary commercial transaction. He knew very well that he had to recredit the 4 million so that he didn't get what's been described as the windfall benefit of the repairing covenants.
Yes, I mean I accept that is one element of the factual matrix that one looks at to determine how this transaction is to be characterised. Although, of course, his lordship at first instance does deal with the fact that at an early stage, Mr. Price made it clear, that he didn't understand the board minutes which referred to this counter indemnity given by PPC, which was the whole reason for the reduction, because he knew there was never any such counter indemnity, and
yes, but it's been found that it was explained to him, contrary to his evidence, that he was told all about the way in which it was final agreement was formulated.
But yes, is not the indemnity and the counter indemnity now irrelevance water under the bridge? As I understood, the issues as to value aren't issues which turn on the 4 million indemnity, counter indemnity, or whatever. They're quite separate issues as to valuation of the property disposal.
Well, that's right.
Yes.
Because the way in which this was this purchase price was worked out, the sale of PPC of this asset was worked out that the value of this asset was £4,063,000, but that you could reduce the value by 4 million because of the release of this counter indemnity, which counter indemnity never existed. So we say prima facie it's therefore at a gross undervalue. There was then evidence at trial, as is effectively adduced by my learned friend, to say, oh no, even if you're right about that, you don't get this at a valuation of 4,063,000 because in fact it was worth only 63,000. In fact, it was worth less than 63,000, and that's why we had 2 days of expert evidence. But because his lordship dealt with it, as it were, on this preliminary point of Mr. Moore's subjective state, we never got into undervalue, and so it was assumed in my favour, as it had to be because it wasn't determined, that it was at an undervalue, and it was therefore assumed at first instance and assumed in the Court of Appeal that there was an undervalue, which prima facie there is, because if you can't depress the price by 4 million, prima facie there's a 4 million undervalue. And it was also assumed in my favour, because it was never determined, that Mr. Moore ought to have known that this counter indemnity did not exist, and therefore ought to have known that it was an undervalue, although he did not in fact know.
The alternative view, although I have the gravest doubts about whether we should go into all this because we're just going to get... But the other view is that the original valuation was an overvaluation on the basis that the original valuation thought that this was a genuine tenant's full repairing and insurance covenants which would be performed, whereas both sides in this case seem to have proceeded on the basis, well, we've created full tenants repairing and insurance obligations in order to satisfy Nationwide, but everyone knows that YMS can't afford to perform them, but we don't want to upset Nationwide, so we're going to enter into leases containing these worthless covenants, and then somehow, and that's where all this nonsense arrives from, isn't it?
Well, I think I would agree with your lordship's opening remarks that it really is not something that we can get into.
Because you don't want to go into the other remarks.
Well, for the simple reason that we're not in any position here to deal with the underlying facts of the case. That they, unfortunately, were not dealt with at first instance.
Well, the judge did his best to sort them out. He gave some of the reasons why he found it impossible to sort them out completely.
But he certainly found, of course, that there was no such counter indemnity, and therefore no reason to reduce the price for that reason. I mean, and he found that he said there was no counter indemnity executed, and so far as Mr. Moore is concerned, he said that the evidence was effectively rather unsatisfactory, that there might have been an intention to honour an assurance, but there was no company ever identified to give an indemnity, and that itself it precluded the possibility of a counter indemnity, and all the witnesses on Millennium Friends' side were unable to identify when or by whom on behalf of PPC such a counter indemnity might have been made. So there was not even an indemnity, let alone a PPC counter indemnity.
That's why he found the whole of this picture was an irrelevance, because the non-existence of the two cancelled each other out.
Well, but of course not an irrelevance from the point of view of it being a purported justification for knocking £4 million off the price.
But surely, I mean, the reality is that if someone had pointed this out at the time, no agreement would ever have been reached on the 20th of October for the sale of YMS. Well, if people had said at the time, that's why the solicitors were so concerned to put references into the agreement to the release of the counter indemnity. If someone had said at the time, there is no counter indemnity, you've got to pay £4,063,000 for this company, Tradegrow would have said, you've got to be joking.
Maybe that's right.
And the transaction wouldn't have gone through.
Well, maybe it might not have done, but it...
Well, they would have said, no, sorry, you've got to give us credit. Yep. Wouldn't they? And they would have been reduced to 63,000 again for perfectly good commercial reasons.
Well, that's maybe. I mean, one can speculate as to, but we are where we are. I mean, I do take issue with the point about windfall and so on, because what actually happened in relation to all of this was the way that the transaction was done, not at purported market value, but not at market value so far as the revenue is concerned, was meant that PPC has suffered at the hands of the revenue, and there has been some tax indemnity reclaimed by the purchaser, but PPC has suffered difficulty. But in any event, if there is a windfall point here, I'm afraid my short answer to that would be that hard facts shouldn't make bad law. And what one does do is one analyses this transaction as to whether it is to be characterised as an unlawful distribution, it having every hallmark of it being so. Not, of course, that has been decided, but we say that it is at a gross undervalue, and it's been assumed in my favour that it is. It's plainly to a shareholder. It's plainly to a shareholder as a shareholder. He's not just Tradegrow's subsidiary company didn't come along as a customer for a property portfolio. It was all done in the context of a corporate reconstruction. There were no distributable profits. And the only thing which I have fallen down on is Mr. Moore's subjective position in circumstances where we say he was, and again this has been, as it were, taken in my favour, grossly negligent and culpable in relation to not knowing that there was no basis to to depress the value by £4 million, and therefore, prima facie, he ought to have known that it was at a gross undervalue. And we say that Mr. Moore's position of saying, I think it's all right, doesn't mean it is all right. It's a matter for objective assessment as to whether it's all right.
And your client was managing director of PPC?
Yes. Yes.
In fact, you did not mention in the particulars of claim in the case.
Well,
you didn't.
Well, I'm sorry about that. I think we mentioned directors, but
You didn't. There is no reference in your pleaded case that Mr. Price was a director of PPC.
Well, it's not something that would have been missed on the part of the defendant in this case. I mean, it was not sought to be a point. And in any event, of course, the whole point about assent and ratification was then pleaded out. And so, but of course, we say also in relation to that we would take issue with what the learned judge said, but we really can't. And in any event, it's not relevant to do so. That assent and ratification doesn't work because it's an ultra-virus transaction, and that's clear on the authorities and clear as a matter of principle. Now, could I? I was going to go to Roll Steel Products, but
just before we do, going to the issue. If a company sells a major asset to one of its shareholders, in circumstances where a director of the company is also a director of the shareholder.
Yes.
Now, why is that important? To fix the shareholder somehow with the breach of duty owed by the director to the vendor?
It's so that there is a complete there's a complete community of knowledge.
Of knowledge. We're not dealing with knowledge. We're dealing with negligent failure to know something.
Yes.
Why is the purchaser adversely affected by this breach of duty on the part of the director in his capacity as director of the vendor?
Because the purchaser is taken to know the law, and if the purchaser knows or ought to know the position, then it's going to be liable.
But it's not really law. The director in his capacity as director of the vendor is in breach of duty to the vendor because he's failed to appreciate that the asset is worth more than the sale price. Now, if the asset was sold to another shareholder,
yes,
would the transaction be ultra vires and void?
Yes, it would. So he procures it at a gross undervalue, not for any personal benefit, but for that shareholder.
So he's just negligent, and he's selling it to another shareholder. And he's in breach of duty to the company.
Yes, it would be, but it would not be recoverable.
Well, if it's ultra vires and void, it's of no legal effect.
Well, but the basis of recovery, certainly on Aveling-Bartha principles, was because of the attribution of knowledge in relation to the recipient, and that then chimes with 277, knows or ought to have known, and yes, if the position is that shareholder knows that if there are no distributable profits, and there is therefore no basis to make a payment to that shareholder, it would be recoverable. Yes,
the shareholder doesn't know. He's ignorant through the director of the vendor believes that this is for market value.
Yes.
In his capacity as director of the purchaser, he believes that he's paying full value.
Oh, so
that
yes,
his company is paying full value.
So the purchaser is the lucky windfall shareholder.
Well, in the facts as you set them out,
yes,
the director who is in breach of duty to the vendor is also stated to be a director
yes.
of the shareholder.
Yes.
I'm trying to find out if this is of the essence of
Yes.
your claim.
So what we would have is a sale at an undervalue to, as it were, an innocent shareholder. I'm sorry to use that phrase, but to an innocent shareholder.
Well, why is the purchaser company not innocent? Because in his capacity as director of the purchaser company, the director's not under a duty of to make sure that the sale is not at an undervaluation.
If, as it were, we have what might be termed a third-party shareholder, purchaser,
Yes.
purchasing an asset for a gross undervalue,
Yes.
it may be that it's not to be characterised as a distribution to that shareholder, but that shareholder is buying not as a shareholder, but just buying as a purchaser. So, for example, I don't know. Let's take something on Bond Street selling paintings, and a painting is wrongly characterised, and a director who knows it's wrongly characterised tips off another shareholder and says, "Do you know, we've got a lovely painting and you might want to buy it." Doesn't say, you know, it's an absolute steal, whereas the director knows it is, and he comes off the street like anybody could and buys it for £5,000, whereas it's worth £50,000 or £500,000. Now, in my submission, that just can't be characterised as a distribution to that person as a shareholder, because it's just a complete misnomer. He's not buying it as a shareholder. He's buying it as somebody off the street. Anybody could buy it as a customer. And he's not trying to take assets out of the company, and he's not getting any form of distribution of assets to the company. So in those circumstances, there may not even be a distribution, let alone one which could be recovered from that shareholder.
Why is it a distribution or anything but a purchase here?
Exactly.
Because there is complete attribution of knowledge in all circumstances.
But there isn't any knowledge of impropriety.
No, there's no knowledge of impropriety, but there is knowledge. There is knowledge that that this is in fact at a gross undervalue.
Sorry, whose knowledge?
There is knowledge of the facts. There is knowledge of all of the facts, and the facts are that there is no basis to depress the value of this sale.
There isn't knowledge. I mean, I thought that was their whole assumption, that even Mr. Moore didn't realise the facts, and I thought your whole case depended upon him having some duty to realise what the true facts were, namely that there wasn't anything to release.
Well, that's right. But of course, what was known, what the actual facts were, was there was no company which had ever given an indemnity, which itself precluded the possibility of a counter indemnity, and there was anybody in PPC was totally unable to identify even who might have given the counter indemnity for a non-existent indemnity. So it was impossibility upon impossibility. Now, Mr. Moore completely negligently thought that there was a counter indemnity, even though no reasonable person could, and I accept he had the knowledge that he did. But these matters are to be judged in my submission objectively. Mr. Moore's in exactly the same position as Mrs. Charlesworth. Mrs. Charlesworth didn't think she was doing anything wrong. She thought she could take the money out as remuneration, but she couldn't. Objectively, it was characterised as an unlawful distribution, and therefore ultra vires. She didn't think she was doing anything wrong. That's why the Holt Garage case is so interesting when set aside Aveling Barford.
But she did know the material facts.
Exactly.
Here,
Mr. Moore knew the material facts. He knew everything. He just hadn't put two and two together in a thoroughly negligent way. He knew that there was, because I took him through it relentlessly for a whole morning, and we got to the end, and the prospect of there being any indemnity or counter indemnity had totally evaporated, and that's why his lordship decides in the core bundle judgment, paragraph 33, that there was just that this whole proposition of there being a counter indemnity and the justification of the reduction in the purchase price had no basis in fact. Absolutely no basis in fact. So we do in fact have Lord Justice Bowen's...
It was the counter-indemnity that was said to be the justification for reducing the purchase price.
Yes, but the counter-indemnity had to counter something, and they couldn't even find an
was...
indemnity, let alone the counter-indemnity. I mean, there was just there were no indemnities at all. So they are taken to know the facts, and they're taken to know the law, and the facts are that there was that a sale at 63,000 was, and it must be taken in my favour, was a gross undervalue, and the law is that you cannot, that a shareholder cannot take assets out of the company as a shareholder, unless, as Miss Justice Pennycook says, it's pursuant to a proper route or for full consideration. And if you don't do it for not full consideration, then it is liable to be characterised, depending on all of the circumstances, as an unlawful distribution. And what Mr. Moore believed about it is not the end of the story. Of course, if he believed it was the wrong thing to do and a bad thing to do, and he did have a heightened sense of awareness because he was very concerned that it should be at a market value. So he's actually in a heightened state as well. It wasn't all just sort of thrown together in a slapdash manner. It can't simply be said that if Mr. Moore thinks it's all right, it is all right. Because if Mrs. Charlesworth thought it was all right, it would have been all right. And if Dr. Lee in Aveling Barford thought it was all right, it would have been all right. But it wasn't in any of those cases. And it would have been the same in Macpherson. They thought they were doing all right. They thought that they were taking out money from the company in order to extricate themselves from the company in Macpherson as consultancy fees, but they just weren't. What they were doing was they were effectively being paid their capital out of the company in order to have, as it were, a sort of a homemade liquidation, and the shareholders go their different directions. And that's why at the end of Macpherson, Lord Justice Buxton says this transaction is in danger of being characterised as an unlawful distribution. And that's what we say I should be entitled to argue in this case. But my argument has been cut off in limine because it's been said that Mr. Moore's state of mind is entirely conclusive, which in my submission simply can't be right. And that's the point. That's the only point. It's all about subjectivity or objectivity. Mr. Moore's subjective belief provides a complete answer and complete exoneration, and in my submission that is simply not right. It doesn't have any support in relation to the other authorities on in relation to ultra vires transactions, whichever end of the scale you're looking, whether you're looking at the whole garage end of the scale or the Aveling Barford end of the scale. And it certainly doesn't gain any traction when you put it next to any form of analogous situation in company law. For example, whether a director is liable for breach of common law duty of care, because a common law duty of care is always subject to objective assessment. And in fact, as a matter of company law, it was set out in authorities and now in the new Act that a director is to be judged according to standards of objective reasonableness, but also in accordance with the actual knowledge and state of mind that he has. So, as it were, so far as that is concerned, he can make his position worse, but he can't make it any better because there's an irreducible minimum of objective reasonableness. And whether you look at how the directors exercise powers in any other context, they are all subject to a degree of objectivity. If you exercise a power bona fide, but for the wrong reason, the court can strike it down. If you exercise, and this happens in all sorts of fiduciary decision-making areas, if you exercise a power totally irrationally, the court can strike it down. And company law applies a test very similar to Wednesbury in that regard, which of course is a test of reasonableness. It's a reasonableness within a range, of course, I accept in relation to Wednesbury. It's not just, would I have taken the same decision? It's would any reasonable person have taken this decision? But that still an element of objectivity. And when you are analysing whether a transaction is to be characterised as an unlawful distribution, you look at all of the circumstances, including the director's state of mind and the state of mind of the relevant people, and you operate accordingly. In this case, the director's state of mind has been paramount and the end of the story. I may not ultimately succeed, but I'm entitled to have my day in court, and I've been choked off in limine. Now, could I just briefly go to Aveling Barford? I think I probably needn't take your lordships to rolled steel. I mean, it's a very complicated case, and the one passage of any moment in rolled steel is referred to in Aveling Barford, but. Aveling Barford, and I'm sure your lordships will have had the opportunity of looking at this, was a case at entirely the other end of the culpability scale from Mr. and Mrs. Charlesworth, and his lordship started with Ridge and dealt with rolled steel products and indeed Halt Garage. And the problematic sentence comes right at the end, which is the sentence which has sunk me in the courts below, because what his lordship, this is at tab 10 of volume 1 of the authorities, right at the very end of Aveling Barford, his lordship is dealing with fraud on the creditors in relation to Lord Justice Slade in rolled steel. And as an example of such a case, he cited Halt Garage. Counsel for the defendant said that fraud on the creditors meant transactions entered into when the company is insolvent. In this case, Aveling Barford was not insolvent, but I don't think that phrase was meant to have such a narrow meaning. The rule that capital may not be returned to shareholders is a rule for the protection of creditors, and the evasion of that rule falls within what I think Lord Justice Slade had in mind when he spoke of a fraud on the creditors. There's certainly nothing in his judgment to suggest that he disapproved of the actual decisions in Halt or Ridge. Now, so that's all so far absolutely classic stuff about unlawful distributions, and his lordship has previously dealt with them being ultra vires and not capable of being validated. As for the transaction not being a sham, this was a sale, I accept that in law it was in law a sale. The false dressing it wore was that of a sale at arm's length or at a market value, i.e. it was a sale at a gross undervalue. And then, this is the problematic sentence, it was the fact that it was known and intended to be a sale at an undervalue which made it an unlawful distribution. And my submission about that sentence is what his lordship is doing is summarising the facts of the case before him. He is not there providing a qualification which effectively completely nullifies the principle pursuant to which he was operating, that is, of unlawful distributions. And because otherwise, that sentence would completely have exonerated Mr. and Mrs. Charlesworth, because they didn't know that their remuneration was wrong or made it was an unlawful distribution. On the contrary, they were wholly innocent, good faith people, but it was still struck down. Now, this case was a much more severe case because they knew. This appears to have been just a scheme to extract from the company a valuable asset for the entire benefit of the shareholder. And when one looks at the facts, they really are disgraceful, miles removed from Halt Garage. And so what his lordship is doing is summarising the case. This is not part of the ratio, and it is not a qualification or a gloss on unlawful distributions, in my submission. So that sentence has been, it's that single sentence that's caused the difficulties in this case, because it's been taken out and approved.
This wasn't a claim under the statute.
No, it was a common law case only.
And that was because there wasn't a distribution to members, is it, or what?
I don't know.
But on your analysis, would it make any difference if it had been a claim under the statute?
No, it wouldn't.
The reasoning
No.
would all be the same.
Yes, exactly, because, as one would expect, the statute and common law move hand in hand. And then, of course, not only is this how I submit the principle should be understood as to unlawful distributions, that's how it was understood by everybody, which is why we had all the company law review material which talked about the Aveling-Barford principle, because it was Aveling-Barford that really brought home to everybody the real danger of a transaction which may be characterised and struck down as being an unlawful distribution of capital. I suppose that, and also my Lord Walker's Bairstow case, which didn't involve labels because it was strictly a dividends case. But it's an important case in my submission, Bairstow, which is also in the bundle, because it explains the statutory provisions, and it also makes it clear that we're talking about where there is a breach of the statutory provisions, a transaction which is ultra vires, not capable of ratification, and that goes back to Lord Justice Dillon in Precision Dippings, which is another unlawful distribution case which was followed in Bairstow. So it was this, the Aveling-Barford principle, which is unlawful distributions are ultra vires, which caused all the consternation and was taken to metaphysically absurd lengths by some company lawyers, with the result that little bit was rowed back from in the 2006 Act. But the principle and the common law aspect of it remains absolutely as true as ever it was. And the Macpherson case, which your lordships also have, I think, in Bundle 2, is a subsequent case. It's a little bit complicated by the fact that it seems to sort of bring Lee Berens back in. But the ratio and decision of the case, his lord in the Court of Appeal is Lord Justice Chadwick, with whom Lord Justice Buxton delivers a judgment, and Lord Justice Peter Gibson agrees. Analyses the situation in Macpherson as to what actually happened. Can I just turn to that very, very briefly? It's Volume 2, Tab 21. There were three people who were involved in a partnership, and they incorporated a company, which was therefore a very close quasi-company, and two of the people had 25 each, and the other one had 50% of the share capital. And they had a shareholders' agreement in 1990, but then they all fell out, and they had another agreement in 1991 in order to deal with their fallout and how they all go their separate ways. One provision of which is on page 691 of the report at F, because some money was due from a contractor to the company. And in the 1991 agreement, which was effectively a homemade liquidation, separation of the ways agreement, clause 8.4 said, thereafter, the monies that come in from this contract will be distributed to the people leaving and to the person staying in the proportions, 25, 25, 50, and that's in proportions as to their shareholdings, as payment for consultancy services provided by them to the company. And so it did have some of the hallmarks of being characterised as a distribution, because it was called a distribution and it was in proportions to their shareholdings, but it was then said as a payment for consultancy services. And his lordship went through and the fact that there were no distributable profits and so on and so forth. And what was found was that they had, to the exclusion of creditors, effectively worked out their own winding up of the business, and to the exclusion of creditors. So, and of course, the whole point about maintenance of capital is for the protection of creditors. And at page 701, Lord Justice Chadwick says that it is, to to enter into an arrangement, paragraph 48 at B, to enter into an arrangement which seeks to achieve a distribution of assets as if on a winding up, without making proper provision for creditors, is a breach of duty. Alternatively, its ultra vires is the company. I think I would say, and its ultra vires is the company. And then he refers to Ridge, and he says at paragraph 49 it's not necessary to refer to it as a sham, but nevertheless it is struck down as an ultra vires transaction. And then he goes on to deal also with section 263, and he deals at paragraph 51 with what the learned judge below said, that the payments which were to be made did not fall within, and this I think picks up what my Lord Clark and my Lord Walker were asking me earlier, didn't fall within 263 because those payments were not to be made to them in their capacity as members, because they were for consultancy services. That's back and the relevant clause was on page 691. Paragraph 52. If I were persuaded that 8.4 of the 91 agreement could have any place in a bona fide transaction entered in for the benefit of prosperity of the company, I'd recognise the force of the judge's view that the fact that the payments were to be made to individuals who happened to be shareholders, and the fact that the amount of their payments were to be in proportion to the amount of their shareholdings, didn't lead to the conclusion that they had to be regarded as distributions within 263. But for the reasons I've sought to explain, those facts compel the conclusion in the present case that the purpose of the parties in agreeing remuneration in the form for which clause 8.4 provides was to achieve a distribution of assets as if on a winding up without making a proper provision for creditors. The vice isn't that the agreement was 263, it is that it was achieving a formal winding up, which is of course is another way of dealing with the matter. But that is where I get my point that 263 is not necessarily as straightforward as it might be, because it can be characterised in a different way, and there are going to be payments to people who happen to be shareholders which are not payments which can be characterised as distributions to them as shareholders. But in this case, that's exactly what was happening, and that's why it was very important, that bit at the bottom of the page, the left-hand side page on Hawke Garage, as to part of the circumstances of Hawke Garage, because what Mrs. Charlesworth was getting, without any further thought to her actual, the actual business that she was doing for the company, she was continuing to get a drawing from the company in her position, really as a shareholder, as a dividend or a distribution drawing, which happened to be characterised as remuneration, but was really a distribution. Now, Mr. Charlesworth was getting exactly the same, but his wasn't struck down as an unlawful distribution of capital, even though the company had no money to pay him as a shareholder, because he wasn't being paid as a shareholder. He was being paid as a director for the services he was rendering as a director. So it was characterised differently. And then Lord Justice Buxton, in the judgment on page 703, says at paragraph 56, he's minded to think that the 91 agreement on its true construction did provide for a distribution of the assets, contrary to section 263. But at paragraph 59, over the page, he deals with the point, as it were, more about whether there was a proper consideration for consultancy services and so on and so forth. So, but he holds it just below C. So to hold that it's a distribution of the company's assets doesn't entail a holding that the agreement was a sham, in the sense that the parties didn't genuinely think they were rewarding each other for past services and were entitled to do so. Rather, the method of reward they chose was in danger of being characterised as distribution of assets, unless the basis on which it was explained and justified was capable of some other construction law, and I'm not satisfied it was so capable.
And that's partly because it actually was called a distribution in the agreement.
Well, yes, but Lord Justice Chadwick, of course, just said that you might use the word distribution because it's a word in common parlance in lots of ways, and the fact that it was called a distribution and it was in fact to them in pursuant to their shareholdings doesn't necessarily make it a distribution of law. But in the circumstance of this case, because they were having a homemade winding up, it was, just as Mrs. Charlesworth's continued to take distributions from the company, to continue to take money out of the company as a shareholder, so to be characterised. So what was done in this case, and then he goes on in paragraph 60, Ultravire is the company, and so on and so forth. And so what was happening in Macpherson, just as what was happening in Aveling Barford with the sale, which was not a sale, just as what was happening in Holt Garage, remuneration, which wasn't remuneration, was, or at least was to be characterised, was an objective assessment was being made, and the proper character of the transaction was being worked out. And if you have a transaction which might be remuneration, or it might be a gift, or it might be a sale, but it's to a shareholder in circumstances of no distributable profits, depending on the circumstances, it is in danger of being characterised as an unlawful distribution. And it just depends what those circumstances are, and all facts and matters are relevant in deciding that issue. And it should be scrutinised accordingly. And there is no magic get out of subjective belief on the part of those who are giving effect to it. Otherwise, it really is Lord Justice Bowen's lunatic direct defence. Now, that was Macpherson. Can I go very briefly to the Court of Appeal? And then I think I'm done, which is in the core bundle at tab 5. There is so much in this judgment with which I take no exception at all, except the conclusion at the end, I'm afraid. And Lord Justice Mummery, giving the judgment, the principal judgment, on page 3, he with respect, quite rightly, says that this is a short, basic company law point, and and at G, the appeal is on one point only, whether PPC's sale of its shares in YMS1 was ultra vires. Although it's accepted that the transaction took the form of a sale of shares, PPC alleged that the price was at a gross undervalue, and it was in truth a dressed-up unlawful distribution of assets. Then there's a reference to Holt and Aveling Barford. His lordship did in fact also have Macpherson, but that doesn't appear in the judgment. And then his lordship deals at paragraph 6 with the belief, the subtraction on the purchase consideration.
Can I just stop there, because I'm still confused about this part of the case. The sale and purchase prices at 63,000.
Yes.
Calculated on the basis of the open market value of the properties, 11.83.
Yes.
Now, is that open market value on the basis of the actual condition of the properties or the dilapidated condition of the properties?
Well, I think it was on the basis of the actual condition, because there was a valuation. The reason it's such a precise figure is there was a specific valuation of the portfolio at 11.83 million.
They needed 4.6 million worth of repairs, as I understand it.
Yes, they did.
And what I'm interested in is whether the 11.83 million was valuing them with the benefit of a covenant which would put them in good repair, or valuing them in their dilapidated state.
I can't remember.
Well, it's rather important.
Oh, well, it is.
Because the whole thing turns on that.
Well,
from which there was subtracted liabilities of creditors. That's from the value of the company.
Correct.
Yes.
Because, and it's important to note here that the value of the shares in the company were treated as exactly the same as the value of the underlying assets, as it were, subject to the company's creditors being taken into account.
Well, these are 8 million for creditors.
Because it was a net asset.
Yes.
It was, if it were, a net asset value.
Can we then go on? And the sum of £4 million
Yes.
in respect of a repairing liability.
Yes.
Now, just pausing there, why is 4 million to be deducted from the value of the company? Whose repairing liability was it?
PPC's.
Well, why, when you're asking what is YMS worth, do you deduct a benefit to YMS that PPC is going to have to spend 4.6 million repairing its buildings?
Well, the point that's then made, the subtraction of 4 million was made in the belief that PPC had given an indemnity, well, in fact, a counter indemnity, under which that liability for a repairing liability
was
would
ultimately going to
fall on PPC. And so it was released from that, and as it turned out, there was no such indemnity and no justification for a reduction in the price.
If you start
You're
with...
saying it's circular, my lord, effectively.
So whether or not there was a belief in an indemnity and a counter-indemnity is wholly immaterial. Surely the value of YMS, it had an internal obligation between YMS 1 and YMS 2 to repair, which was worthless. The ultimate liability for 4.6 million of repairs initially was going to fall on PPC, so that was an asset of YMS that it was going to be indemnified for the cost of repairs. So you start with the dilapidated buildings, you have the asset of a repairing covenant from PPC which would enhance the value of the package, but for the fact that the PPC counter-indemnity, if you like, was going to be nullified.
Yes.
So you fall back to the basic value of the dilapidated properties. And that's why I totally fail to see why any confusion about indemnities and counter-indemnities of any relevance at all, and how you can base a contested case now against Mr. Moore on the basis that he was in this muddle.
I will seek to answer that, possibly just after the short.
Well, I think the answer to my lord's first question is perfectly plain in paragraph 19 of the first instance judgment at page 18 of the appendix. That the properties were booked at vacant possession value. That's
Yes.
without tenants' leases with FRI covenants at 8.62 million. On the face of it, their value increased by more than 3 million by the execution of the FRI leases.
Yes.
But so long as it all remained in the group, this was a bit of magic or bells and whistles or something, but because no one had any intention of actually doing the repairs. And that's why this, the whole business of the indemnity and the counter-indemnity buzzing around somewhere in the group. Because so long as you believe in an indemnity and a counter-indemnity, you've magically increased the value of the group assets by 3 million.
I think I can see that, and I'll seek to come back to this, but it may be that simply basing my case on this aspect of it with gross undervalue, it's certainly how it has been viewed below, and indeed was viewed by my learned friend, because that's why they then sought to say that, well, even if there was no indemnity, and I can't subtract 4 million because that's how the maths was in fact done, then we say, as a matter of fact, when you go out and value these things, we had an expert to do it, it was worth a lot less even than £63,000. So we didn't need to take off this 4 million because the real worth of this property portfolio was absolutely nothing.
Well, one can see that. I mean, that's an alternative argument. But
yes.
One gets back to the basic point that in reality, this on one view of what happened, the assets of PPC were sold at full value, 11.83 million, 12 million in round terms, and there was an erroneous belief that Moorgarth, Tradegro, had a claim against PPC under a counter-indemnity, which would give rise to a set-off against the price, and instead of just setting it off, they actually released the counter-indemnity. So that, in fact, there wasn't a sale at an undervalue, there was a separate aspect of the transaction in respect to which there was a mistake, which has nothing to do with the value of the subsidiary. Why isn't that an analysis?
Well, it is, but it's not the end of the picture either, because in the way that your lordship said that the way that my learned friend dealt with it, by having a valuer to say, forget all of these indemnities and counter indemnities and so on and so forth. I'm just going out to value these properties, and they are worth less. This whole portfolio is worth less.
That's just his alternative way of dealing with it.
Yes, but I have an alternative way of dealing it as well. And that is, I'm afraid, that likewise, leaving all this point out of account, my valuer says that it is worth a lot more than £63,000, not having regard to any of these indemnities and so on either. And the value.
These are all presumably matters for some future trial judge, are they?
Well, they were before this trial judge, because we had 2 days of expert evidence. Each side's expert was.
Yeah, but he didn't decide.
He didn't.
They're nothing to do with the issue before us at all.
No, they're not.
But I thought what the judge did decide was that the indemnity and counter-indemnity confusion was an irrelevance, so that you're left all right with the question of what were these properties worth?
Yes.
Were they sold at an undervalue? And if they were sold at an undervalue,
Yes.
should Mr. Moore have been aware of that fact?
Yes.
Quite apart from his confusion.
Quite apart from this confusion.
Yes,
Well, I suppose what it boils down to is this: that in my fascinating point of principle on company law, I don't want your lordship to say, but there's no way you can possibly win because of this natty point. In my submission, that doesn't work because quite apart from all of this, the experts are thoroughly not ad idem about the valuation of this property portfolio. And I say, on whatever basis, and I'm entitled to say it and have my day saying it, that it was a gross undervalue. And that's why it comes to your lordships on the assumption that there is an undervalue here, and that it was an undervalue which Mr. Moore ought to have known about, so that, subject to it being finally decided, all of the elements are there for this being an unlawful distribution, except one, which is the one I lost on.
Yes, but it's one thing to say that Mr. Moore knew all the facts which demonstrated that the sale was an undervalue, which you were arguing some while ago by reference to the indemnity and counter-indemnity.
Yes.
It's another to postulate, one, that the sale was an undervalue. Two, Mr. Moore should have known that it was an undervalue.
Indeed.
But then the third thing you need is it not? And furthermore, he knew all the facts which demonstrated that it was an undervalue.
Yes. That's exactly
in order to get that knowledge into his mind as the director of the purchaser.
Correct. And I say I will get there on that. I do, and I'm bound to say also that when this goes back, an awful lot more has come out of the woodwork since this. I mean, the Millennium Friends expert is going to be in a very difficult position, because his very self-same firm was coming up with a valuation which was completely at variance to the expert's valuation, and he obviously hadn't done checks within the firm as to what the value, as to his position as an expert, and there's going to be some serious further argument in relation.
This would involve a completely different nature of knowledge on Mr. Moore's part, nothing to do with the indemnities and cross-indemnities, but actual knowledge about the real value of the properties.
I think it might actually. I think given that's what's come out now, I think it might get much worse. Yes. And it'll be much less of an interesting argument about objectivity and subjectivity, and it'll be much more like an Aveling Barford case of actual knowledge, or perhaps actual knowledge as a result of blind eye. But that's not in my submission for today or for your lordships. It does genuinely come to your lordships on this point of principle, which was the point of principle which was decided against me by Lord Justice Mummery in the Court of Appeal. And just returning very briefly to that, and I'll be able to finish by the short adjournment. So his lordship, almost on whatever basis, proceeded on page 4 on the assumption, just as the learned judge did, that there was a share sale at an undervalue, to paragraph 7, and then he refers to the inability to ratify ultra-vires transactions, and then he says at paragraph 10 at H that as the vendor and the purchaser of shares were under the same control, the situation was no different in principle from a transfer of assets direct to the shareholder. So it made no difference that Moorgarth was a subsidiary of the shareholder. There was absolute identity of knowledge and a community of knowledge because of Mr. Moore's position having a foot in every single camp, PPC, TradeGrow and their subsidiary Fold-Free Moorgarth. Then he refers to the legal proceedings, and at paragraph 12, that there was no dispute before the Deputy Judge that Mr. Moore genuinely believed that the sale was at their market value. And at paragraph 14, common ground that if his decision is reached on the assumption of an undervalue was wrong in law, it will be necessary for the issues of valuation and possibly also of what Mr. Moore ought to have known to be remitted. Then his lordship sets out the judgment, and at paragraph 16, Aveling Barford, having caused some alarm in the company world about potential impact on intragroup transfers, which was perhaps a metaphysical alarm, but it was in any event put to bed by the 2006 Act. And paragraph 7, never been contended that it was ultra vires in the strict sense of being outside the express powers in the memorandum. And then at paragraph 19, I pursued an optimistic and not very vigorous submission as to strict liability, which was in fact a wrong submission. But the alternative and narrower submission, and my submission, the correct one, is at paragraph 20, that Mr. Moore ought to have known the transaction was an undervalue, unreasonable and negligent, no basis. And then I make a point about collateral purpose, and then 263 conceded that added nothing to the common law position. Either the sale infringed both common law and statutory provisions, or it infringed neither. And then paragraph 23, with respect, that's quite right, and 24 and 25, Aveling Barford and so on. And then he goes on to deal with the end of Aveling Barford at paragraph 8, and in particular that last sentence at just between C and D, the fact that it was known and intended to be a sale at an undervalue, which made it an unlawful distribution. I'm unable to accept Mr. Collins' submission that the rule against distributions of cattle to shareholders applies in this case simply because, through TradeGrow Mr. Moore's connection, PPCs were sold to Moorgarth at an undervalue, as the Deputy Judge was prepared to assume. Nor is it rendered unlawful because Mr. Moore ought to have appreciated that the sale was an undervalue. And that was, as it were, taken in my favour again, that it ought to have done. The fact is, he did not. Miss Justice Hoffman plainly made it an essential part of the reasons that the sale was known and intended to be, and that's that last problematic sentence. But then his lordship goes on, and in my submission that's not correct with respect, because that last sentence was summarising the facts, and as I said before, not a qualification on the principle which nullifies the principle in toto. Paragraph 28, a similar approach had been adopted by Miss Justice Oliver in the Hawke Garage case of excessive remuneration. Remuneration had been paid to a person who was a director of the shareholder of the company, but for a number of years done no work. When the company went into CVL, the liquidator claimed repayment of the sums to the director as having been ultra vires. Oliver J. ordered repayment on the grounds that payments could not reasonably be described as a genuine reward for service, and inferred from the objective evidence that the payments were called remuneration, though not made with any intention to defraud, were in substance disguised gifts out of capital. Now, pausing there for a moment, what his lordship there is saying with respect is absolutely right in relation to Hawke Garage. That's exactly what happened. There was objective evidence, there was no intention to defraud, and his lordship worked out what was reasonable as a reward for service, i.e. Mr. Justice Oliver applied throughout objectivity. Mr. Justice Oliver rejected as the criteria of virus such considerations as whether the payments were reasonable, whether they were for the benefit of the company. Absolutely right. That's the Lee Berens point. That's the Lee Berens now sideshow, because the misuse of a power doesn't mean to say you haven't got the power. In my judgment, the question whether they were for an improper purpose would likewise be irrelevant to the issue of virus. I agree with that. Those considerations were primarily management matters for the shareholders, not for the court. The correct test to be applied by the court on the issue of virus was to look to the true nature, absolutely the true nature, the objective, what was in all the circumstances the truth there, and the substance of the payments, and assess their genuineness. Well, that's objective. In this case, the Deputy Judge noted had been accepted by PPC that the sale was entered into in the belief on the part of Mr. Moore that it was a market value. In those circumstances, there was no knowledge or intention. There was no reason to doubt the genuineness. This was so even though it appeared calculated on a basis misunderstood. In my judgment, the Deputy Judge was right in holding that the sale of YMS was not a disguise. It was an intra-vires sale of shares for a proper purpose, even if, as was assumed, it was won at an undervalue, and even if, as also assumed, it too, Mr. Moore ought to have appreciated that fact. The authorities demonstrate that the issue is whether, on the facts they were genuinely perceived by Mr. Moore to be, and having regard to the nature of the character of the payment, could properly be characterised as something other than gratuitous distribution. And that's where we say that's not right. But then he says, enabling Barfoot and Holt, the payment, or at least part of it, could not. Here, the payment could only, in this case, the payment could only properly and objectively be characterised as consideration for the sale of an asset without any element of gratuitous benefit. No, there was no objectivity in this characterisation at all. The objective element was entirely made superfluous by the subjective element of Mr. Moore entering into it in the belief that the agreed price was at a market value. So in my respectful submission, this part of the judgment is confused between subjective and objective, and it's quite clear from the authorities that objectivity is what you need, and subjectivity is not a complete panacea. There was one authority which I wanted to hand up to your lordships. Could I give it to your lordships and perhaps just return to it very briefly at 2:00?
Yes.
Because it deals with a point that I apprehend may be made by my learned friend in relation to one case, and it is important because it goes. Thank you very much. It goes to this point about whether or not what we're doing here is seeking to upset a director, whether you're seeking to interfere in the management of a company from the point of view of a director's commercial decisions or managerial decisions. This is an extract from a mammoth judgment it's the sort of Tito and Waddell of our day, of Mr. Justice Lewison. You can see from the only pages that I've given you, which starts at 345. But it neatly encapsulates the point about vires in my submission, and answers the issue that may be raised, that in fact you may not go behind these sorts of decisions because we'd be second-guessing management and so on. But Mr. Justice Oliver, of course, second-guessed, as it were, management for directors' remuneration, because he said, no, it just wasn't. In all the circumstances, it just was not directors' remuneration. That took it out of being a managerial decision, which the court should be very loath to interfere, and into the realm of characterisation as an unlawful and ultra-vires distribution. So, my lords, if that would be convenient.
Very well, we'll adjourn until 2:00.